my great enjoyment to introduce our friend Steve Mashuda. And I have a bit of a bio here to let people know who they'll be listening to. Steve grew up in Pittsburgh near polluted rivers. That sounds educational right there.
It's also kind of redundant.
Yeah, okay, it's redundant.
Yeah.
After college, he traveled to Wyoming and Colorado, which prompted him to study environmental law in Vermont. Go figure. Then he moved to Montana, where he was hired as an attorney at the Bozeman Office of Earthjustice, where he brought cases to protect water and native species in and around Yellowstone. In 2000, he joined Earthjustice's Seattle office and soon became project attorney for Save Our Wild Salmon, an effort to dismantle 4 Snake River dams to restore the world's once largest salmon and steelhead in the Snake and Columbia rivers. That led to his efforts to protect southern resident orcas in 2005. The carryover of orcas and salmon. Let's see, I think I need to get this back going there. Earthjustice began as a Sierra Club legal defense fund in San Francisco in 1971, but was independent of the Sierra Club. So in 1997, they changed their name to Earthjustice, which provides legal representation at no cost to more than 1,000 clients like the Wilderness Society, NRDC, National Audubon, and smaller coalitions. In 2012, Earthjustice, representing several groups, that's a year ago, January, filed suit against the National Marine Fisheries Service, accusing it of failing to protect orcas and other sea mammals from the dangers of the Navy's sonar. And Earthjustice is on the case to find the cause of death of 3-year-old L112, who washed up a year ago in about a week. The title of his talk is The Latest Effort to Remove the Endangered Species Act Protection from Southern Resident Killer Whales, a Misguided Effort. I think we know where Steve is coming from here. So, take it away, Steve.
So, bear with me just a second while I get this PowerPoint going. Just realized that I titled this PowerPoint something different than the title of my talk, but they're both equally relevant. Thanks, Howard, for that great introduction, and thank you all for coming. It's kind of intimidating looking out at this audience to realize that most of the people in this room know more about the southern resident killer whales than I could ever hope to. So please, if I make errors, feel free to either shout out or tackle me afterwards. Either one will be fine. I'm going to talk a little bit today about what I think the title sort of tells you, the latest effort to remove southern resident killer whales from the list of endangered species. As you'll see in the next few minutes, hopefully, this isn't something new. It's unfortunately something we've seen before. And if you count the times trying to get the southern residents listed on the endangered species list, in that we've seen it at least twice already. And so what I want to do is give you all just sort of a very high level view of what's going on in this latest petition that many of you may have heard of or already commented on by the Pacific Legal Foundation down in California to ask NIMS to remove southern residents from the endangered species list. Quick show of hands, how many people have ever heard the term distinct population segment? Okay, and how many of you know what it is? Well, that's, I would count myself among that latter group as well, only because this is a part of the Endangered Species Act that, given its ambiguity and given its different interpretation by different people, continues to cause trouble in many different arenas. But today we'll talk about just southern resident killer whales. Again, knowing my audience, I should have gotten rid of some of these slides, but there are 3 commonly known ecotypes in the North Pacific, transients, residents, and offshores. And I won't go into detail about why and what the different habits of all these are, but they do play a role in what I'll be talking about. Amongst the residents in this part of the world, we have the northern residents up in Canada and our own beloved southern residents down in our neck of the woods. This is a very old slide. I couldn't get a new one. I saw Ken earlier. I may hit him up for something that gets us from 2008 to 2013. But again, this slide really just shows you what the decline has been over time in this population, with obviously some fluctuation, as you would see in any wild animal. There are generally three major eras for this decline, at least as we split it up. The first is the era of live capture, where about 34 whales were removed from the population alive, 12 killed. That obviously took a huge toll on the southern residents. The second decline was the result of those removals, which is a reproductive gap and a demographic problem that when you remove a lot of animals who are eventually going to reach their reproductive time from the prime from that population, well, the population will decline. And then the third, which is really what led to the efforts to get the southern residents put on the endangered species list in the early 2000s, and that's a decline, a pretty rapid one, back in the late 90s and early part of the 2000s. It's generally recognized to have been caused by, there's never any one silver bullet or one factor, but the number of factors contributing to that include toxics and pollution, reduced food supply, which is a fancy way of saying less salmon, oil spills and other pollution in the water, and then vessel traffic, noise, and all of the things that go along with things that we humans do. So I'm not going to get into legislative history, I promise you, or focus too much on the statute, but this is the definition in the Endangered Species Act of what a species is. And it includes any subspecies of fish or wildlife and any distinct population segment of any species. And it's again, limited to vertebrates. We won't talk about why plants and invertebrates were left out of this, but they were. But for today's purposes, orcas are obviously a vertebrate, so we have, this definition applies. Now, the phrase distinct population segment was added by Congress actually after the first version of the Act was passed. The Act was first passed in 1973. The distinct population segment language was added in 1978. And really, it has no commonly biologically accepted meaning, which again is why I think it continues to cause controversy or provide openings for others who might have different views than the National Marine Fisheries Service about what it is to come in and raise those views. It isn't, I've asked a number of biologists over the years if anybody could tell me what it means, and I get different answers from different people. So I'm fairly convinced that it's not something that we could all just say, well, the language of the statute is clear and that's the end of it. The other thing to notice about this is that the word species includes subspecies. So basically, every time the Act refers to an endangered species, it's referring not only to species as a taxonomical term, but also the lesser included subspecies, and also the lesser included distinct population segments. Now, because this term is so ambiguous, the National Marine Fisheries Service and the U.S. Fish and Wildlife Service came out in the mid-90s with a policy that explained how they would apply it. They said that there were two main characteristics they were looking for to determine whether a population or a group of animals is a distinct population segment. The first of those is whether or not it's discrete, and that means whether it's either markedly separate from other populations or whether it's separated by things like our own arbitrary impositions of things like international borders or state borders, or anything that would subject a certain portion of a population to a completely different regulatory regime. A good example of this is alligators in Florida and Louisiana. When the act was passed, alligators in Florida were listed as endangered species, alligators in Louisiana were not. That had a lot to do not only with the different status of those populations, but also with the different ways state law treated those animals. And then the second factor is significance, which in and of itself is pretty ambiguous. But the way the services defined it was to say that if it's an example of a portion of a species that persists in a unique ecological setting, whether its loss would result in a big gap in an otherwise contiguous spread of a species, or whether the population genetics and other characteristics differed from other parts of the species. So when southern residents were first petitioned for listing, groups asked the National Marine Fisheries Service to add the southern residents as a distinct population segment. When the service, this is under the Bush administration, took a first look at that, they came back and said, well, there's only, if we look at taxonomy, there's a worldwide species of Orchinus orca, and that's it. There is no formal taxonomic recognition of subspecies. There's no taxonomic recognition of anything smaller than that. We just have orca, the second widely most distributed mammal on the planet. And based on that, the National Marine Fisheries Service came back and said, well, we don't really know, we don't have taxonomic classifications to point to here, but we still have to apply this Endangered Species Act definition that includes these terms subspecies and distinct population segments. And the big stumbling block there, and I think continues to be, and this plays a role again now, is that the system of classification and taxonomy proceeds pretty slowly. And one of the reasons for that is it's mostly still based on the same principles applied in 1758, which include collection of skeletons and skulls. And for a lot of species, we just don't have that. But we do have today a lot of other evidence that was not available to Linnaeus in 1758 in order to classify species. And so the service said, well, even though there's only one worldwide recognized species of orcas, we will delve deeper. And we'll look at the southern residents as a distinct population segment. And they found, when they did that indeed the southern residents are distinct. They are distinct not only from other ecotypes, but they're also distinct from northern residents. And that, boy, they aren't doing so well. They are, in fact, probably endangered. But because of their adherence to the worldwide classification, they said, well, you know, taxonomy says there's only one species of orca, and there sure are a lot of them throughout the world, and so they're not significant. These southern residents are not significant because we've got a lot elsewhere. And they said some things that we had a good time making fun of in court about how, well, even though the southern residents colonized Puget Sound, for example, after the retreat of the glaciers in the last ice age, it doesn't mean that, you know, they're anything special, because if we lost them again, maybe others would come back and colonize these waters as well. 10,000 years is an awfully long time to wait for the species to come back. But really this sort of boiled down to sort of Dr. Seuss moment where because we don't, you know, if you start looking at smaller populations of animals and deciding, well, we don't need these here and we don't need them over here, eventually you're not going to have them anywhere. This is sort of the Aldo Leopold principle of, you know, the first, I'm going to misquote this, but the first principle of intelligent tinkering is to save all the parts. Well, this is the reverse of that. So we took the agency to court over that decision and won. And the judge said some very good things about its reasoning. he recognized the science that came out that even the agency knew about, which was that whatever the taxonomic classification of a global species sort of is still formally on the books, there's a lot of people, a lot of scientists who've already recognized that that's not correct. There are, in fact, many different probable subspecies as well as other populations within that. We just haven't got around to sort of naming them yet, and taxonomy hasn't caught up with that other science. There was no evidence that would support the theory that if we lost southern residents, that other whales would just come and take their place. And the court emphasized that the agency really needed to consider the unique behaviors, the unique physical traits, the morphology, and the culture of the southern residents. And so lo and behold, when it did that, it came back and listed the southern residents as endangered because the writing was on the wall. And in doing so, the agency found that the southern residents were a distinct population segment of an unnamed or sort of unformally classified subspecies of northern Pacific resident orcas. Now this is a very important finding because this is the basis, one of the bases, I should say, for the petition I'll get to in a moment, I promise, for attack. Because the agency said, we recognize that the scientific evidence shows us that there is not one worldwide species, and that there are indeed many subspecies, and we don't have anything to point to that sort of classifies those yet, but we look at the science and we know that one thing is wrong, so we're going to do our best to sort of establish the subspecies that this population segment belongs to, and that's what they did. And then they found, for all the reasons we've already talked about, that it was in fact discrete and that it was significant. The threats that listing was based on are the same ones largely that were responsible for some of the decline: the loss of food, the declines of salmon, toxic contamination, risks of oil spills in Puget Sound and elsewhere, and vessel traffic. Now, shortly after the southern residents were listed, the Building Industry Association of Washington, represented by the Pacific Legal Foundation, or PLF, filed a lawsuit, and they said that the service cannot list a distinct population segment of a subspecies. And the way they get there is interesting and tricky, but it ends up being wrong, that because the term species, as defined by the Act, includes any subspecies in any distinct population segment of any species. So they said, well, it's a distinct population segment of any species, not a distinct population segment of any subspecies, which kind of makes sense if you're just looking at this. But the thing that everybody needs to know is that the rule that we all learned in grade school that says you don't define a word by using that word doesn't apply to Congress. And when Congress defined species, it said the term species includes any subspecies. And so every time after that line in the Act, essentially, and whenever Congress says species, it means species or subspecies, right? So the PLF reading of the statute is, well, species means species, but the statutory interpretation reading of the statute says species means species or subspecies. Now we had great fun briefing this. We were all ready for a decision from the judge to toss this out. But we had raised an issue, and so had the government, whose side we were on at this point, that the Pacific Legal Foundation and the building industry had not shown that they were harmed. Fundamental principle of federal practice, and one that we spend an awful lot of time on, is that you can't get into court unless you're hurt by something. And in order to show you're hurt by something, you usually have declarations or testimony from people describing how the federal agency action harms them, whether it be economically, whether it harms their recreational interests, whether it harms their aesthetic interests. Something needs to get you in the courthouse door. And these guys didn't provide any evidence that anybody was harmed, and in fact said that they couldn't find any evidence that anyone was harmed. And that's a red flag right away for a federal judge who said, well, you're dismissed because you haven't shown that you have what's called standing to bring this case. You haven't been harmed, so I can't decide your case without you having some stake in the outcome. And the case got dismissed. And we were all very happy and thought, as it turns out wrongfully, that it would all go away. Well, fast forward to 2012, the Pacific Legal Foundation, on behalf of a couple of agribusiness interests in California's Central Valley, filed a new petition with the National Marine Fisheries Service to delist the southern residents. The first, there's really only two elements to this. The first one is their argument that a DPS of a subspecies cannot be listed. And so they're raising that whole point all over again. The second one is that they have a couple of studies that they point to argue that the northern residents are not, in fact, a subspecies, and that classification by the agency was an error because new evidence has shown us that they are not, in fact, a subspecies. Before we get to why both of those things are wrong, there are two things I want to say about the petition in general. It doesn't say anything about the population status. It doesn't say anything about the threats that continue to face southern resident killer whales. This is not an argument that we have successfully recovered the whales. This is not an argument that they're not in trouble. In fact, they explicitly, or implicitly I should say that none of that matters. It doesn't matter that there's only 84 southern residents out there right now. It only matters that the agency messed up in this, our sort of pet legal theory, as well as this species and subspecies determination. So that gets to why now and why California? And there's really one answer. So these are photos of different aspects of the Central Valley Project in California, which is essentially the system of massive river alteration and irrigation canals and water deliveries that have been engineered in California in order to grow crops in the Central Valley over the last 75 years or so. This system has obviously had a huge impact on the Sacramento River, the San Joaquin River. It's the two biggest rivers in the Central Valley, and also on the San Francisco Bay Delta. The amount of water reaching the delta in some years is inadequate to support salmon or to support delta smelt and other species. So the National Marine Fisheries Service has gotten involved and evaluated. These are all, for the most part, federal projects. So the National Marine Fisheries Service's job is to look at the impacts of federal projects. And it found in 2009 that the operation of the Central Valley Project was, in fact, jeopardizing the continued existence of a whole host of salmon runs and steelhead from, they call the Central Valley home, and then went one step further and said, and not only are you causing jeopardy, which is, again, jeopardizing their continued existence, a pretty serious conclusion, to those salmon runs, but you're also jeopardizing the continued existence of this fragile orca population that depends on salmon. And this all goes back to the fact that southern residents, as we all know, don't spend all their time in Puget Sound. They range out on the coast as far south as Monterey Bay. Sure, almost everybody in this room knows better than me that they've tracked K-25 and other members of KPOD presumably down to Southern California here just within the past few weeks, or excuse me, to Northern California within the past few weeks. So there's a number of salmon runs that these orcas rely on, and some of them are, in fact, from the Sacramento River and from the Central Valley. You get rid of them there, we've got a problem. Well, rather than sort of, well, I shouldn't say rather than, those interests have gone after the biological opinions on the basis of salmon, tried to get them thrown out in order to get rid of the salmon protections. But now with this petition, they've taken that one step further in sort of a belt and suspenders approach, I suppose, of getting rid of protections for the southern resident killer whales as well. And so they've raised all these same arguments again. There are a number of legal reasons that I could bore you with for hours why that's wrong. But here, I think, if I can get this audio to play, if I don't, I'll say it. But here's really what it boils down to. Darn. I hit. No, it may be that I'm using the wrong version of PowerPoint. Let me try one more time. But I'll then tell you what it is, because so again, as I mentioned, sorry about the lack of sound. As I mentioned, Pacific Legal Foundation has raised this argument before, not only in the context of southern residents, but also in the context of a bunch of other species. And we argued a case before the Ninth Circuit back in 2007 about coastal cutthroat trout in the Columbia River, which was a distinct population segment. And Pacific Legal Foundation and its lawyers came in and intervened on behalf of, I can't remember who, and raised this argument again about the distinct population segment of a species or subspecies. The audio clip here was about the portion of the oral argument where the attorney for Pacific Legal Foundation stood up and said, here's the argument, and the judge interrupted him before he could even start and said, "Counsel, I honestly don't understand your argument. If you gave a 6th grader a Venn diagram, they could understand that if something is a subspecies, it's also part of a species, and so it doesn't really matter whether you're listing a distinct population segment of a species or of a subspecies. It's going to be a distinct population segment of a species." And I thought, boy, that was brilliant. I could have never, we spent 20 pages of briefing trying to explain the exact same thing that this judge picked up on and regurgitated in a crisp, understandable way in about 20 seconds. They didn't win. Sometimes the writing is on the wall at an oral argument. So we are raising all those same arguments again in opposition to this petition in comments to the agency. We'll raise them again in court if they take it that far. I hope they don't, but I don't believe that my hope will pan out. But then the more interesting and I guess new question presented by this petition is, did NIMS NIMS, National Marine Fisheries Service, I'm prone to slip into acronym land, did they properly consider what subspecies southern residents are a member of? And here they look at, one of the things, in order to be generally classified as something, whether it's a distinct population segment or a subspecies, there's got to be some insularity to your population. There's got to be boundaries that you can draw around it, right? And so one of the boundaries that was drawn around the residents, the North Pacific residents by the agency, was that they don't interbreed with different ecotypes, at least not on any sort of recognizable mass scale. And that's one of the reasons to consider them a subspecies. They have different genetics, and those genetics are maintained through breeding within their groups as opposed to breeding with everyone else. And so there was a study that came out in 2010 that looked at genetic evidence at DNA to try and determine if there was any inbreeding between different ecotypes of killer whales. And this study found, looked at about 30 samples or so, and found that there was in fact some evidence that some members, some offspring of different ecotypes were likely fathered by males from a different ecotype, which is not terribly surprising necessarily, but it's also, it's not terribly detrimental either. And the reason for that is that we've got a couple other studies that look just at southern resident killer whales, look at a lot more samples, as well as the history and the observation and the documentation of offspring in the southern resident community that says these whales seem to breed within the confines of resident whales. Now, the other thing is that the Endangered Species Act doesn't really focus all on genetics. It doesn't focus on paternity testing exclusively. That's relevant evidence, and no one's saying it can't be considered, but it doesn't drive the determination. Because basically the Endangered Species Act recognizes that even subspecies interbreed. Even some species are capable of interbreeding and producing offspring, fertile or not, but they're capable of interbreeding and producing offspring. You know, cows and buffaloes, lions and tigers, all of these things, you know, things that have mainly been driven by human intervention, but they're still capable. It doesn't mean that lions and tigers aren't different species. They are, but if you're only looking at that one factor, you could say, well, they're capable of interbreeding and producing offspring, so they can't be the same species. And the ESA recognizes that. Just because wolves and coyotes can interbreed doesn't destroy a wolf population for the purposes of protecting it under the Endangered Species Act. And in fact, the distinct population segment policy that I mentioned before specifically allows for some level of interbreeding. I don't know where that came from. All of these issues are in front of the National Marine Fisheries Service right now, teed up by this petition. The service, I think, did something that at least surprised me and decided to give this petition a full review. There's kind of a threshold that the service has to sort of screen things through in order to, whenever they receive a petition. And they screened this one and said, well, it meets that threshold and we'll go forward. I honestly, you know, back in August when this first came out, I thought, well, this isn't going anywhere. But they are giving it a full review, and they have opened it up for public comment. That public comment period closes tomorrow, or excuse me, Monday, at 9 o'clock our time. There have been about, the good news is there's been about, as far as we know, and this is just sort of organized comments by Earthjustice and Center for Biological Diversity and some of our other client groups, so far 76,000 or more people weighing in favor of protection. If you have a spare minute and haven't already done so between now and Monday at 8:59 Pacific time, I would encourage you to do so and just add your voice to the mix. But one of the things that we are emphasizing in comments is not only the points that the legal points and the biological points referenced earlier, but also this point that there's no question that if you get past these sort of threshold structural issues that they've raised, that this is still a population that deserves and in fact requires Endangered Species Act protection because the threats still remain. Salmon populations are still across the board not doing well. There are exceptions either way within that, but the general trend is either flat or declining. Noise from all sorts of sources, and including the Navy, are still out there and still impacting the population. Toxic pollution is still a huge problem. Both legacy pollutants like PCBs and in Washington State, PBDEs are now almost officially a legacy pollutant as they were banned for sale here several years ago, but they're still showing up in other states, in other products, in other countries, still getting into the waterways. Stormwater runoff, which carries everything that comes off our cars and on our street into the waters where these whales spend a lot of time. Still a huge problem. So I guess my message to folks is that hopefully at some point we'll get past, you know, we're, quick math, Steve, 7 years past the listing, and we're still arguing about whether these whales should properly be protected under the Endangered Species Act, when we really ought to be arguing about the bigger picture questions about what we do and what we need to do to save them. My hope is that this is the last gasp of efforts to keep calling the question on whether we should be doing anything at all, and that we move past that and we start talking about recovery a lot more than we talk about whether or not we ought to even be talking about recovery. And again, I would encourage everyone here, if you're so inclined, to again add your voice to the mix. It doesn't have to be a scientific voice. The agency needs to know that people very much care. And I think even if you don't have any special training in science or law, that does not preclude you from telling the service what you think. So And I'll open it up now for questions.
On your website?
Yeah, well, unfortunately, I learned yesterday that we just took our action alert down at 5 o'clock yesterday afternoon in order to get the comments in on time. But I do know that the Center for Biological Diversity still has a action alert up on its website that will, take you through and have your comments submitted. You can also go directly to a federal website called regulations.gov. And if you just type in southern resident killer whales, it will pull up this as the top thing on the list, and you can click on that, and there's a submit a comment box, and you can do it there. You can upload a Word document or some other file if you want to. So questions? Yes.
In the 2010 study, the DNA study,
Mm-hmm.
was were the residents breeding with transients, or were the southern residents breeding with northern, or what?
Yeah.
More specific.
Well, I think, so this is where I get a little fuzzy, and maybe there's somebody in this room who might know this study a little bit. I've read this study, and it's difficult for me to figure out whether they have specific samples of southern residents breeding with transients. There's a lot of evidence, they looked at whales from all over, not just the southern residents. They have some examples from Iceland, they have examples from other places. So this was sort of a broad, they looked at 30 or so samples from a very broad group. And I have not been able to say definitively that there's nothing in that study where they showed any paternity potential from transients in the southern resident population. They did show it for other whales for sure, but I'm unable to get my head around the samples and the acronyms used in that study thus far to sort of say definitively. I do know that I should just add real quick. There is there was a paper by Ford et al. In 2010 or 11 that looked at about 70 to 80 different samples of southern residents in particular, applied the same methodology that's in this 2010 paper, and found no evidence of that. So that's sort of the counterweight, I guess, in some respects. Sorry, over here.
I'm curious about the legislative maneuvering in the 70s. Who caused the amendment to be brought up in 1978, and if it's now becoming just a basis of argument on verbiage or semantics, why in the ensuing years hasn't somebody amended it to take that offensive,
Right.
distinct population definition out?
Yeah, I think I'll answer your second question first, and I think the simple answer to that is no one from any side of any debate has really been able to or has pushed very hard to reopen any parts of the ESA for quite some time now. But going back to how to get there in the first place, it was actually added to give the services more flexibility in protecting populations that were declining. And that's the strange thing, is it's turned into more or less a sword for not protecting populations instead of a shield that it was intended for. The language that it replaced was something like smaller taxa in common spatial arrangement, which nobody knew what it was, and the services looked at it and focused on the taxa thing and said, well, we were sort of limited to taxonomic considerations. We can't look at things beyond that. And Congress said, no, we want you to look at things beyond, taxonomy, and we want you to look at evolving science and things. So we're going to add this language, distinct population segment, in order to do that. And that's very clear from the legislative history surrounding that provision, but it's not, that has gotten, we obviously bring it up, and one of the reasons I think courts have not bid on this argument so far is that it was intended to be something much more protective than how it's being used.
So the first time the challenge came up, they didn't get standing, and so the case wasn't argued. This time, the case is going to be argued. Hopefully it's going to turn out that the argument loses. Do they just move to another jurisdiction and bring it up again?
That's always the danger. The thing that prevents that from happening is if it loses and they take it up on appeal, for example, and it goes from somewhere, you know, a district court within one of the western states up to the Ninth Circuit Court of Appeals, then it gets decided there, then it's sort of final as to, you know, California, Alaska, Washington, Oregon, Nevada, Idaho, Montana, Arizona. I mean, this will sort of take it off the issue for a large chunk of the geography of the country. So